Let me quickly introduce our moderator, Dabney O'Riordan. She's a partner at Quinn Emanuel based in Los Angeles. She previously served for over 17 years at the SEC, where she was the longest serving leader of the SEC Enforcement Division's Asset Management Unit. And she also led the LA office's enforcement program as Associate Regional Director. Dabney, thanks so much for moderating.
Oh, thank you very much. Thank you, Gurbir. I'm going to dive right in because there's a lot of questions and you've now left me with 20 minutes and 30 seconds. And so one of the things, I actually have a follow-up from one of the points you made in your speech, if you don't mind.
Sure.
You talked about the fact that there are opportunities and there have been decisions to make declinations. And unfortunately, obviously, there's no public order when that type of decision is made. But in looking at the public orders that are out there, it's hard to really divine as the defense bar, like what tips it into a declination from some of these other cases we've seen?
I mean, it's difficult because unlike the DOJ and other, for example, the FCPA unit, I think publishes their declinations and is able to put that information out. So we're thinking of ways to get that information out. Certainly, there have been declinations during my time. There have been declinations early in the investigative stage where the evidence may not have supported a violation, or maybe the matter was better handled with a referral to examinations or to another regulator. There has been precedent in the past where we've published declinations, where we've gotten authorization to put out there an order that speaks to why a matter, we declined to bring charges in a particular case. I think there's one example of that, if I'm right. I don't know, Tice is nodding his head. Yes, yeah. And so I think those are things that we want to think about and work on. Certainly, we invite you, if you want to get your clients' names out in the paper when we've declined to move forward. That's always the challenge, right? And so, but they happen for a variety of reasons. A, because the facts don't support the violation. B, it's probably better handled in a different way. Or C, it's not the best use of our resources to handle it. Or it could be because an entity identified and corrected the misconduct at issue, and it was sort of a blip. I think all those facts have presented in cases where we've not moved forward.
Okay, great. I'm sure that the speech that you just gave, as well as all the sites, will be closely read by the bar as a whole. So
yeah. So pro tip: the reason I wanted to do that is because you can't really publish when you're just giving comments, and that speech, hopefully, when it goes up, is going to collect all those cases from the last 3 years where the commission has recognized cooperation, provided reduced penalties or no penalties, or given other types of credit for cooperation. We think that's really important for each of you to have as you navigate those conversations with your clients, and as you come in to talk to us, to point to those other precedents and say why your matter should fall into that category, which you all do so adeptly.
Great. So next I wanted to turn to Panawat, and Panawat has actually been discussed on 2 earlier panels already today, at least 2 earlier panels. And so one of, I'm not going to rehash what the case, I think we're all very aware of what that case is about, and I'm not even going to try and say that it's a novel theory or anything like that, because I know the SEC's position on that. I will couch it as more of a novel set of facts, perhaps, and one of the things I wanted to ask about is what are the takeaways you want people to take from it, other than don't engage in insider trading?
It's a pretty good one.
It's a good one. But one of the things that really the defense bar is talking about is that a lot of this case seemed to hinge on the company's policies and procedures, and that creating the duty, and whether or not really firms should really be revisiting their policies and procedures and trying to focus them to just what is required under the law, and not creating potential exposure for their employees by drafting policies that may be broader than needed. So is that one of the takeaways firms should be taking?
I don't think so. I hope not. No. And it's hard to really not to have this conversation without looking at the facts of this case. So, they probably were discussed earlier, but I think it's super important for folks to know that Medivation, the company where Panawat worked as the head of business development, was in a really small space where they were the target, an acquisition target by Big Pharma. There were other players in the same space, other smaller public companies also being targeted. And I'll be brief, but Medivation went to Pfizer because they wanted to up the offer they were getting elsewhere. And in those conversations, Pfizer agreed to terms and to acquire Medivation at a significant premium. And Insight, the competitor, was another potential company that was being targeted at this time in this particular space. And so what did Mr. Panawat do? Within 7 minutes of getting that information, he went and placed the largest trade he's ever placed, bet the equivalent of a year's salary on short-term out-of-the-money call options in Insight stock. And they paid off. And they paid off because what he did was insider trading. And I don't think we want to be in an environment where simply because they didn't have that policy, that's okay. I'm sure that's not the message we want to send, that this type of behavior stealing information you get from your employer and then trading on it in this way is okay. But getting to Panawat, the case itself, fact pattern novel, legal issues not novel. He had a duty to his employer, right? One of the bases for that duty was the policy that you talked about, but there were two other independent bases for that duty. Another confidentiality agreement that the court pointed to as supporting the duty, and the third was agency principles. So on summary judgment, they tried to make these arguments. They were rejected. The court said there were three independent bases for his duty of confidence and trust to Medivation as employer. So it's not dependent on that policy. I think the policy was just one example of why there was a duty. But we also had to prove, in addition to the duty, as you know, the three other elements for the misappropriation theory in that case, which were, that he got MNPI as a result of his position there. That information was material to Insight, which we established. And then he traded on that information in breach of his duty with Sienter. After a 2-week trial and 2 hours of deliberation, the jury agreed with us. So the takeaway shouldn't be from that case that if you didn't have that policy, or employers shouldn't have those types of policy. The takeaway from that case should be that we take a pretty wide view on insider trading, that we are looking at all the different ways in which insiders can capitalize unlawfully based on information asymmetries and profit in a way that the public cannot. And so the takeaway from that case should be that your policies should be looking at all the ways in which your employees might gain access to MNPI and to work to address them and to control it. So like 204 Cap A is a perfect example. I mean, we're uniquely focused on 204 Cap A, so advisors are looking at all the ways in which they may come into contact with MNPI. We're curious about how, if you're looking at ad hoc creditors committees and situations like that where people are getting MNPI, are there policies in place when people get access by virtue of these various types of relationships that they might have with companies that they're invested in? And so I think that should be the takeaway from all these cases, that we take a wide view of the different ways in which insiders can access information and profit from it in a way that the public can't.
So in terms of...
Did Rahul answer it the same way? Yeah, okay.
Exactly.
I wasn't here for
exactly
that.
the same way.
Can I also say, I caught an earlier panel, and the defense bar's interpretation of some of the opinions in which we prevail is really different from mine.
I think the takeaways on Panawat, everyone may have a slightly different view.
I was talking about
as
the
well.
Coinbase opinion.
Yeah, I think that as well. So I wanted to talk a little bit about sweeps. I know the clock is ticking down. So in terms of sweeps, I mean, I know from my time at the SEC, and so do many others, is that they can, grouping cases into sweeps can be a really effective way of communicating an issue, and it can also be a really efficient way for the staff to use their resources. And over the last few years, we've seen repeats of some sweeps. We've seen repeats of the off-channel communications. We've seen repeats of the marketing rule and a few others. And I wanted to ask you a little bit about what you consider in deciding to repeat a sweep. And using the off-channel ones as an example, that those first ones were brought in September of 2022. And according to the orders at the time, it explained it was a sweep that had started the year earlier. And I will say from my personal perspective, those were very effective at getting across to the industry. I think the industry has taken note of the issue and really tried to make changes. And so my question really goes to, at what, in your analysis and how you consider how to approach repeating sweeps for historical conduct, I'm not going to get at, if it keeps going, where do you consider to draw the line on that issue?
So the question is, should we do the sweep, wait for a period of time to see if there's compliance, and then only then go back?
That is one option to consider in terms of when the money's not necessarily going back to harmed investors.
Sure.
Yeah.
So, I mean, listen, you talked about why sweeps and initiatives are so effective. They are much more effective than bringing a case one at a time, and it sends a message and people have taken notice. I wouldn't say that this is a repeat, what you're seeing. I think it's really just sort of a continuation of the efforts that were underway. When we started those initial investigations, as you know, there's sometimes a latency and you have investigations underway. Some resolve earlier, others resolve later. And we're not just uniquely in the broker-dealer space. You have now enforcement actions in the advisor space. You have enforcement actions among credit rating agencies and others. So the NRSRO cases, we've had a number of them recently. So I don't really so much see this as a repeat as much as it is a continuation. A lot of the conduct here too has straddled the line that it's post-dated the announcement of the JPM case in December of 2021. And so I think that sort of speaks to the fact that a lot of times, some people change behaviors, but others don't. And so that's one thing. And the other thing is I don't know if it's the right thing to do if your approach and the market and the industry knows it is that, all right, we'll do it once, people will wait for somebody to get caught and then they're not going to do it again for a while. And so we're off the hook, right? I don't think that sort of helps create a culture of compliance. So I think there's some value into having sort of a continuing effort for a period of time. And I think, and it's not forever, right? There will come a time naturally where we move on to the next thing. This goes on to an examinations. You pass it off to exams. Or we deal with it more harshly when it presents in another case, in the context of another investigation. So, I think that's sort of where we are in my mind. As far as money going back to Treasury versus harmed investors, I don't think that should be a thought as to whether we should continue these or not, because, for example, the marketing rule, we're targeting people who are engaging in really unsavory tactics and using hypothetical performance and targeting their marketing to people to whom it may not apply, or there might be other issues with it. I think that protects investors, regardless of where the fines from those cases go. I think the monies that are being recovered from the off-channel communications matters, regardless of the fact that they go to Treasury and not return to harmed investors, I think that protects investors because we need to be able to conduct our investigations efficiently, like we talked about a moment ago. We need to be able to get the documents, see what happened. And so efficient investigations protect investors. I think those types of violations may be symptomatic of bigger issues at an entity. So I think that helps draw attention to these types of issues and, again, improve compliance. So, I think that's the way I look at it. I don't see this as a repeat. I think it's a continuation. I think it has benefits regardless of where the fines go.
I will say I do think the industry has heard a message pretty loud and clear on this one. So, but it'll be interesting to see when those eventually are determined to be hopefully not needed anymore, because there's a better compliance. So.
But it's like cyclical, right? Like we did the 21 F-17 sweeps years ago, where firms had these policies and clauses in their settlement agreements that violated Dodd-Frank 21 F-17, the whistleblower protection rule. And then we're doing another one, like 8 years later, because people correct for a while and then they, tack back and start to engage in these practices. So, even the answer of like stopping and seeing what happens might not be the perfect answer. So it's really, as you sense, how people are improving their procedures. And I agree with you. This particular one has more of an impact than I've seen in any other space.
Right. So that was the reason for the question is like, how do you judge when to stop? When to maybe take your foot off the accelerator, I guess, not to stop, to your point. Yeah.
And when did you decide to do with the share class?
With the share class stuff, when I got really tired of, no, that wasn't it. That wasn't it. I will say on those cases, as I say often, is the money went back to harmed investors in that case, in those cases. So it was harder to kind of just walk away from those. Fair. So, yeah. But I get the question all the time. Because,
I should get your bullet points.
So, I want to talk a little bit about DebtBox.
Yep.
And there's been a lot of ink spilled on DebtBox over the last few months. And what I just wanted to kind of open it up to you to what message do you want the industries the SEC regulates to take from what happened in that case?
I mean, I think the message everyone should take is that we take the allegations and the findings, because there are more than allegations in that case, in the court's opinion, seriously. I said this before DebtBox. I said this, I think, in my first set of remarks to the enforcement staff, that integrity matters and credibility matters in the work that we do, that so much of the work that we do is based on that trust and that credibility and that integrity that we have. Our work with the defense bar, you need to be able to trust what we say to you when we're negotiating a resolution. The court needs to be able to rely on our representations. I think as government attorneys, we really should measure ourselves against higher standards. And this was not us at our best, but it's also not indicative of how 99.9% of the staff does its work. And so we've acknowledged our shortcomings here. It was important for me to put in the declaration personally. I think there was a lot of question of why I did it, but ultimately I have to own that. I have to admit what went wrong. I have to take responsibility for it, and I have to commit to the court that we are taking this seriously and we're implementing ways in which we could all learn from this. And so we've had retrainings of the entire staff. We've had accountability at a personnel level. But again, I underscore that this is not symptomatic of a wider issue. You've worked at the commission for 17 years. You were an enforcement lawyer. So many people in this room have worked there. These are public servants who don't try to round corners to get quick wins. These are public servants who square corners and are trying to make the right decisions for the right reasons and come to the right outcomes because they are passionate about protecting investors. That's why we show up every day. And that's why we continue to do this despite the criticism, despite the headwinds from courts, despite the headwinds from litigants, despite the headwinds from those who want to strip away all of our authorities, despite the headwinds that we face on the Hill yesterday. They continue to push forward because they care about investors. So we're learning from it and we're moving forward.
As you said, I was there for 17 years. I would agree with you that it was more anomalous than representative, I would say, of the division and the staff and the care with which they take their work. So one of the questions I did have about that, though, is now that, it can occasionally happen. It's a very big division with a large number of people. And when, in DebtBox, there was a judge who could call out the issue. In an investigation, there's not. And so, investigative line attorneys have a lot of power with their subpoena authority. And do you have any recommendations for defense counsel if they run across that I'm going to say rare, instance where things may be getting a little bit out of control? About how they handle that problem, because this is also the person who's deciding if they're cooperating and making these assessments.
Sure. Great question. I mean, I think if you take away anything from my remarks earlier, it's that we want you to communicate with us, that we think that this process is best when it's a collaborative one. And if issues like that present, raise them. Raise them with the assistant director, raise them with the senior officer, raise them with me. We've gotten plenty of reach out from attorneys directly when they're concerned about how a particular matter is being handled. The part about the judge being there to call balls and strikes. At the end of the day, if an investigation results in an enforcement recommendation, you're going to put in submissions. You're going to put in a Wells paper. You're going to put in things that you want the commissioners to see when they're making that decision. If there's been that sort of issue in an investigation, certainly that will present in those documents that go to the commissioners themselves when they're assessing whether or not to vote in favor of an enforcement recommendation. So there are opportunities. We're not sort of here running amok without anybody supervising. We have great assistant directors. We've got great senior officers who are trying to get this right and are there to listen to issues when they're raised by the defense bar. The thing I will say, though, is that what I have seen in the wake of DebtBox are a lot of copycat sort of DebtBox letters to us. And we're going to kick the tires on everything. And you have absolutely every right to raise those issues and concerns. But a lot of times, I will say, in the vast majority of those cases that are presented recently, there's no there. And so what you risk doing in that sort of situation where you're saying, oh my God, this is the same thing, you risk losing your credibility with us. We will never hold that against your clients, but you risk losing your credibility in your interactions with us when you're escalating something to this level and it doesn't pan out. Because we're going to take all of this seriously, whether debt box happened or not. This is so important for us to get this right and to have our credibility with you in the courts. And so I think that's something that should be part of this conversation.
No, that makes sense. It has to be balanced, and that's understood. And I was pointing out that the anticipation would be these would be rare conversations or issues that you have to raise. I will say, having been now on this side for a little bit, getting through that Wells process, and you've done the Wells, this is an incredible, and I think you pointed out that it's an incredibly labor-intensive, costly, harmful process for firms to go through. And so if it's being driven by perhaps something other than the facts and the law and everything like that, it can be very costly to firms. And even though it's really rare, extremely rare, I would say, it does have costs. So I think that's what drives a lot of people. But I hear what you're saying on the other side is you can't just be throwing it out all the time.
I mean, I think, that's the message we're giving to the staff, that we want to move our matters. We want to get to the right results as quickly as we can, but we don't want to cut corners. We want to make sure we're doing everything right. And again, by all means, the takeaway should be that if you have concerns, raise them. But, let's make sure that there are real issues here.
I have about 5 other questions, but I know I'm out of time, Bruce, so
I'm not
going to keep running.
I did well.
So,
Thanks.
Thank you.
Thanks, Abby.
Thank you so much. Thank you.